If it pleases the court, my name is Callaghan, initials GB, and I appear on behalf of my client, James Beeston, a 14-year-old Indigenous male from Townsville who has been charged with 5 counts of breaking and entering and committing an indictable offence under Section 421 of the Criminal Code and 32 counts of burglary under Section 419 of the Criminal Code. Per Schedule 4 of the Youth Justice Act, James is considered a child as he is not yet 17 years of age. I submit to the court that Your Honour ought exercise the power vested in the court under Section 590 A, subsection 2E of the Criminal Code to set aside the Crown's evidence as inadmissible. I submit to the court there are 2 grounds for the exclusion of the Crown's evidence, the first being on the ground of public policy and the second on the ground of fairness. Regarding the first ground of public policy, Your Honour, my client's statements were obtained through the contravention of numerous statutory requirements under the Police Powers and Responsibilities Act, the PPRA. Your Honour, the first breach has occurred under Section 418, which states that when being questioned, a person on an indictable offence, such as break and enter, if the police are to question them, the police have an onerous duty to inform my client that they have a right to speak to a friend, a relative, or a lawyer prior to being questioned. On the facts, this did not occur. Another breach of the PPRA has occurred under Section 421 with regards to the questioning of children. On the facts, the officer regularly referred to my client as young fella and, when returning to the station, provided my client with a support person. This is evidence of the fact that the officers did in fact know my client was a child. Section 421 of the PPRA also requires that when questioning a child, an officer must not question the child until the child has been allowed to speak to a support person chosen by the child. The person chosen must be present during questioning. On the facts, the officers selected a support person for my client, a social worker by the name of Roger Smith, a complete stranger to my client, Your Honour. This is in direct breach of Section 421, subsection 2A of the PPRA, and I draw the court's attention to the District Court decision of the Crown and L, where it was deemed that a field officer for Indigenous legal aid was not sufficient as a support person as they were not chosen by the defendant. I also submit the officers were in breach of Section 431, subsection 1 of the PPRA, and Section 26, subsection 1 of the Police Powers and Responsibilities Regulations by failing to inform my client that he had the right to remain silent. In fact, when my client was placed in the interview room with the social worker chosen by the officer, he was actually informed by this social worker to simply answer all the officer's questions as they were simply doing their job. Your Honour, I highlight this point to evidence the egregiousness of the officer's disregard for my client's rights. Further breaches of the PPRA have occurred under Section 436, subsections 2 and 4, with regards to the large amounts of inaudible audio on the recordings relied upon by the Crown in evidence. With reference to the words of Crown and Day and Anor, it's important interest to the public to protect individuals from unfair treatment from those who are charged with upholding the law. To do otherwise would encourage officers to flaunt the law. The defence requests that you exercise your judicial discretion to exclude this evidence. I request that in exercising this discretion afforded to the court that Your Honour consider the case of Bunning and Cross. While the defence concedes that the cogency of the Crown's evidence is in fact high, the probative value has been greatly diminished on the background of extensive statutory breaches by these officers. Nothing on the facts suggests that the breaches were accidental or unintentional, and in fact they occurred repetitively and for extensive periods of time. There's also nothing to suggest that there was any urgency in obtaining the evidence. I respectfully submit that the contravention was calculated, flagrant, and as a result go against public policy of ensuring that those who are charged with enforcing the law ought not disregard it. It's on these grounds, Your Honour, that I request the court deem the Crown's evidence, per public policy, as inadmissible. In regards to the second ground of fairness, the defence requests that the court exercise its discretion under Section 130 of the Evidence Act to rule the Crown's evidence is inadmissible. This is based on the case of Hasler, which employed the Christie principle. This principle states that the court should only exercise its discretion not to admit evidence provided the evidence is small, the probative value of the evidence, rather, is small, and the effect of admitting the evidence would be greatly prejudicial to the defendant. I bring the court's attention to gratuitous concurrence. My client is an Indigenous male, moreover an Indigenous child. It's well known, and has been highlighted in the case of Purcell and Vandernoes, that Indigenous people face great difficulty when confronted by authority and cultural differences. The Crown has acquired their evidence by a means that can only be described as culturally insensitive to my client and through the use of intimidation. The admissions from my client were clearly obtained through gratuitous concurrence. My client's a child, easily intimidated, who was put in a confronting, unfamiliar situation with authoritative figures and no support. As a result, this has led to my client simply agreeing with the questions asked and blindly following instructions. As a result of this gratuitous concurrence, the probative value of the Crown's evidence is greatly diminished. Moreover, to include such evidence, Your Honour, would be highly prejudicial to my client. It's on these facts that I request that on the basis of fairness, the Crown the court deem that the Crown's evidence is inadmissible. In conclusion, Your Honour, the officers in question have extensively breached statute, flagrantly flaunted the law. I respectfully argue that to admit the evidence obtained through these breaches would go directly against public policy, supporting the idea that those charged with upholding the law need not abide by it. This, in my humble opinion, would risk opening the floodgates to improper authoritative practices. Secondly, I argue that based on fairness to my client, the evidence should be deemed inadmissible on the grounds of gratuitous concurrence, something officers use to their advantage during their interaction with my client. Your Honour, to quote Meles Zenawi, the rule of law is the basis for democracy. And without the rule of law, Your Honour, we have chaos. Thank you.